in a second marriage or perhaps a non-traditional family, what are the estate planning implications of that? Well, here to talk with me about that is Harry Margolis. He's the author of Get Your Ducks in a Row. Harry, welcome.
Good to see you, Bob. This is an interesting topic.
Yeah. So where to begin?
Well, begin by thinking about it and talking to your partner about it. So our law is set up kind of with the presumption that everybody gets married once. It's an Ozzie and Harriet situation. They have two perfect children. Everybody gets along, and there are no problems. But the reality, of course, is different. People have different relationships. They get married, they get divorced, they don't get married. They have children with different partners. Stepchildren come into the picture. And whenever that happens, it means that estate planning is actually much more important. And you really have to think it through. I mean, if it's a second marriage, really think about a prenuptial agreement, because the prenuptial agreement will state what the interest of the two spouses are and what will happen if they get divorced, or from our point of view, for estate planning purpose, more importantly, is what will happen when one of them passes away. And then, of course, have to make sure that the estate planning documents reflect that. And you can always change it. So if you have a prenuptial agreement that you made when you're getting married, and 10 years later, that really doesn't make any sense because things have changed, and what you were worried might be a temporary relationship is clearly going to be permanent. You can always change the agreement, and you can change your estate plan accordingly. But if you don't talk these things through and set up a plan accordingly, you can have real problems. These are kind of cases that kind of a lot of bad things can happen. So there can be disagreements between two sides of the family. One partner dies first, and everything ends up in the name of the other partner and goes solely to their family, excluding the family of the first one to pass away. People can become estranged just because just what happens during life, especially when there's an evil stepmother or stepfather. I put evil in quotation marks. So the most important thing is to talk it through with your partner about what you would want to happen, whether it's when one of them passes away or if one of them becomes disabled and incapacitated, needs care, and then implement it. So whatever you agree, put it in writing. And whether that's your estate plan or just an agreement between you, or formalize into a prenuptial or postnuptial agreement, it's really important to have it in writing, because we all should know that our memories are fallible. So my memory of what I said or agreed to 10 years ago is going to be different from your memory of it. And we both might be acting in total good faith, but just have different memories. And if you write it down, you might say, well, that was crazy for me to agree to that, but you did agree to it. And that's what your frame of mind was at that time. Yeah. So put it in writing and then implement it, I guess what I would say. And this is, again, especially important if it's not your first, if you're not in this Ozzie and Harriet situation where it's one marriage and one set of children with one set of parents.
Yeah. It sounds like in your experience, you've seen more than your fair share of second marriages where maybe a husband or wife has children from their first marriage and they want to make sure that the assets get passed down to their children from their first marriage. They could do that a number of ways, I would imagine, one of which we've talked about in the past, beneficiary designation, right? They could actually name their children from their first marriage as the beneficiaries of their IRA or 401k or life insurance.
Right. So they can do that to make sure something goes to them. Yeah. They can, I think it often makes sense. I mean, often what they'll do is set up a plan where when the first spouse dies, things go into trust for the surviving spouse. And then when the surviving spouse dies, everything gets split among the two families. And that makes sense in theory. But the problem is, I mean, there's a bunch of potential problems. One, especially if there's a big difference in age between the spouses, the children of the first spouse that died could be waiting a long time. And during that long time that they're waiting, a lot can happen to those assets. So either they're spent down entirely, so there's nothing available, or they somehow over time end up going to the family of the surviving spouse, or the surviving spouse can get remarried and new things can happen. So I think it is a good idea, usually, even though you may want a large part of your estate to stay in trust for your surviving spouse or go directly to your surviving spouse, is to give something to your own side of the family when you pass away and not make them wait and not have this kind of having them to kind of play nice with the surviving spouse so that they don't get what's theirs taken away from them in some way.
Yeah. And I'm sure you've seen cases where children from a first marriage because they weren't maybe included in some sort of asset distribution, are now maybe suing their stepmom or stepdad to claim assets that they think were theirs.
Right, right. And sometimes the stepmom is not doing anything wrong, but they suspect that the kids of the spouse that died think they are. So I had a case in our office like that, where for some reason they thought their father was much wealthier than he was. And they created a lot of trouble. And the stepmom made a few mistakes in kind of how she did the probate and kind of the process, but she wasn't stealing any money. And a lot of money went to lawyers on both sides before the children accepted that.
So where we began seems like the best advice, maybe get a prenup to put all this in writing. And obviously, when you get a prenup, it's best to work with an estate planning attorney to do that, right? Not to sort of do it on your own.
Yeah. But even doing it on your own is better than not doing it at all.